Hi, welcome to another edition of Tobin Talks. My name is Michael Tobin. Today we're going to talk about disputes under a standard FAR/BAR residential contract. All right, now, most of the time when parties sign a contract to either buy or sell property, things go very well, and the contract results in a closing. Someone buys, someone sells property, right? Just like the contract provided for. Sometimes that doesn't happen, and sometimes the parties mutually agree to part ways and release escrow. Contingencies weren't met, the parties weren't satisfied, both sides agree, okay, let's cancel and walk away. What we're going to talk about today is the third instance, where we don't get to a closing and where the parties don't agree on the release of escrow and the cancellation of contract. This is what results in a dispute. We can have either a buyer who doesn't close or a seller who doesn't close. We can have a buyer ask for the return of their money in escrow with the settlement agent or attorney. We can have a seller make demand on that same escrow for the buyer's money. When the parties are not in agreement on either a closing or on a release and cancellation, that's what we're talking about now. Disputes can come up in a variety of ways, but what's important to know is if you find yourself in a dispute, or you're a real estate agent who finds your buyer or seller in a dispute, it's very important to know that if you've used the FAR/BAR standard contract, and most nowadays everyone uses the FAR/BAR contract, FAR being the realtors, BAR being the attorneys, we've got both sides agreeing to a contract. It's great to have a standard contract. It's great to have a standard contract because we know when there's a dispute that this contract will contain a pre-suit mediation requirement. Now, why is that important? It's important because when we get to court one day, things get expensive, time-consuming, stressful, and uncertain. We want to avoid court at all costs in a dispute. We want to resolve disputes sooner than later. Well, this FAR/BAR clause requires that the buyer with their attorney, the seller with their attorney, attend mediation with a non-binding mediator in an attempt to settle disputes before they have to go to court. And these are usually very successful. We can either negotiate a partial release to one party with the other party getting the majority of it. We can agree that the transaction should continue, and we can work out our disputes and we can get to a closing. That's always the best. Or we can agree that we're not able to resolve this case at pre-suit mediation and that the court is going to be needed to resolve this. So, if you find yourself in a dispute involving a real estate contract, the first thing you should do is know if it's the FAR/BAR standard contract. If it is, you should understand that you will have an opportunity to resolve your case before it needs to go to court, and you should make every effort to do so. You should always hire an attorney. If you need a good attorney, call our office. We're happy to speak to you. And before we forget, please subscribe to our channel and be ready for the next Tobin Talks. Thank you very much. Bye-bye.